Hi, everybody. I'm Eric Berman, and this is my partner, Dan Blinn. Welcome. So glad to have you. Dan and I are partners with Venables advertising practice. And before we get going, just want to just say something on a personal note, because Dan and I have been colleagues now for about 6 years, and for about the past 5 years, he and I have taken a role in putting together Venables' annual advertising law symposium, which I know a lot of you who are listening today, we've been very fortunate to have you attend that live and in person in our pretty glass building that we're in today. And we were planning on having this type of panel in person in March, and just very, very sorry that we had to postpone it, but that's the world that we live in now. And we will see you all again, and we will break bread with you all again. But in the meantime, thank you for joining us virtually. And an extra special thanks for our 4 wonderful panelists. This should be a lively and interesting discussion. This is day 3 of our virtual NADA symposium. And we certainly hope that those of you who dialed in on Tuesday and Wednesday learned something and found the discussions interesting. And will also find today's discussion worthwhile. So why don't we introduce our panelists? We have attorney advisors to 4 of the 5 FTC commissioners. Unfortunately, Danielle Estrada, who is the attorney advisor to Chairman Simons, had a last-minute conflict, but to paraphrase Meatloaf, 4 out of 5 ain't bad. So we've got Austin King. Austin is an attorney advisor to Commissioner Rebecca Slaughter, where he advises her predominantly on consumer protection issues. Prior to joining the FTC, Austin was with the Consumer Financial Protection Bureau, where he was counsel in the Legal Division Office of Law and Policy. Earlier in his career, Austin was a clerk for Senior Judge Rakoff at the Southern District of New York, and then Judge Katzman with the U.S. Court of Appeals for the Second Circuit. He got his bachelor's degree from the University of Wisconsin-Madison, a master's degree from a little school in Boston called Harvard, and his law degree from NYU. Thank you for joining us, Austin. Sam Levine is an attorney advisor for Commissioner Rohit Chopra, where he advises the commissioner on enforcement actions, rulemakings, hearings, and other consumer protection matters. Sam was with the FTC in its Midwest regional office, which is based in Chicago, prior to coming to headquarters, and was with the Illinois Attorney General's office before then. Sam clerked with Judge Shatter in the Northern District of Illinois. He is a graduate of Harvard Law School. While he was a student at Harvard, he actually argued a case before the Massachusetts Supreme Court. Thank you for joining us, Sam. Eitan Levison is an attorney advisor with Commissioner Noah Phillips, also focusing on consumer protection, privacy, data security. Eitan was in private practice with Covington and Jones Day before going to the commission, advising financial services firms, and before then was also with the CFPB. He was one of the first dozen or so employees in the Office of Enforcement. He helped establish the office and lead investigations there. Also served as a trial attorney in the public integrity section of the DOJ. I cannot tell you where Eitan went to school, and perhaps he does not have a Juris Doctor and is not licensed to practice law at all, but you can correct us in a minute, Eitan. And last but certainly not least, Bobby Spector. Bobby is Commissioner Christine Wilson's attorney advisor. Long and illustrious history with the FTC. Prior to working for Commissioner Wilson, Bobby was counsel to BCP Director Andrew Smith. She worked in the Division of Advertising Practices. She's worked in the Division of Enforcement. She was counsel to Jessica Rich when Jessica was the BCP Director, as well as Tom Paul when Tom was acting director. And she's encountered a full range of consumer protection issues. She worked in private practice before coming to the FTC, went to GW for both undergrad and, like myself, got her JD at GW, which means I assume she is the smartest person on the panel. So thank you all for joining us. Oh, and I would be remiss if I didn't say, I'll say it once so that we don't have to hear it 4 times. But as is usually the case when we are fortunate to have representatives of the Federal Trade Commission, Austin, Sam, Eitan, and Bobby are speaking in their personal capacity. What they say reflects their own views and not necessarily those of the commission or any individual commissioner. So with that, I'm sorry,
before we jump into the questions, for those attending on the phone, you can submit questions in real time. There is a chat box apparently up on your screen. So, we have questions that we'd like to ask, but if you have something that you're interested in, please ask the question. It'll be fed to us and we'll try and address it in real time.
Absolutely. So, why don't we kick this off by talking about each of your bosses for a few minutes. For people who don't live and breathe the FTC as some of us do, the commissioners might seem like sort of these monolithic overlords atop the agency, but they're human beings also. Dan and I have known some of them, from previous stints in private practice and elsewhere. But for our audience's benefit, give us a little bit of background about your commissioners, background prior to them becoming commissioners, anything that might inform their view of consumer protection issues, any fun facts that would not normally show up on LinkedIn or in someone's bio. Austin, let's start with you. Tell us something about your boss.
Sure. Thanks, Eric and Dan. I joined Commissioner Slaughter 2 years ago, which was not long after she joined the commission after a career on Capitol Hill. She was chief counsel to Democratic leader Chuck Schumer in the Senate, and her portfolio with Senator Schumer covered a lot of the issues that she now addresses at the commission, including antitrust and consumer protection, and they were always the favorite parts of her docket when she was on the Hill. So she jumped at the chance to continue to pursue those exciting areas as a member of the commission. You can read her bio online. She's brilliant, went to Yale undergrad, then Yale Law School, served on the law review. She did like a nanosecond in the private sector, but otherwise has really been a public servant for her entire life. In terms of fun facts, there is a thread you'll see in many of her public appearances and speeches, which is that she's a major theater nerd. So when she was an undergrad, she told her parents, maybe she'll become a lawyer, but maybe she'd like to be a stage manager on Broadway. Now, that career didn't pan out, and she ended up probably making the right choice. But you'll see references to, for example, Into the Woods woven into some of her speeches. There are many theater references throughout, and we enjoy a lively intra-office theater discourse. And I know it's something that she particularly misses in these pandemic days, the chance to get back into a live theater.
I think that puts her in good stead at the FTC, doesn't it, Austin? I know Tara Kozloff, who has been an advisor to several commissioners and chairpersons and is now a BC deputy, is also a self-styled theater nerd, as well as our advertising law partner, Melissa Steinman. So there must be something in the water in the ad law consumer protection world and the FTC world.
There are many of us, that's for sure.
Nice. Eitan, please tell us something about your boss.
Sure. So good morning, everybody. I feel a little exposed that everyone now knows I do not have a JD. It's my dirty secret. No, in my attempts to be like Sam in every possible way, I attended the same law school as Sam. So this will sound a little bit similar to Austin's introduction. Commissioner Phillips also comes to the FTC after a long period on the Hill. He was also chief counsel to, in this case, to Senator Cornyn. And not surprisingly, among the many topics that he advised the senator on were antitrust and consumer protection issues. And he worked, I think, pretty closely with Commissioner Slaughter. I think they would both tell you that they've worked closely together when they were on the Hill together, and have definitely looked for opportunities where they could work together at the commission, and they've done a whole bunch of panels together. So they have quite a good and longstanding relationship. Even though he is definitely not a theater nerd. In terms of a fun fact, I always have trouble coming up with one of these. This will be a fun fact about myself and the commissioner. So as opposed to most Washington connections, which are made at the coffee shop or the golf course, at the pool, someplace like that, the commissioner and I first met actually, of all places, apple picking, where we were both apple picking with our kids about 3 years ago, which was my first time meeting him. And about 6 months after that, I ended up going to work for him.
Very, very cool. Sam, you're up.
Sure. And thank you, thank you everyone for being here. Like Eric said, I work for Commissioner Rohit Chopra. Commissioner Chopra is a little unique on the FTC in that he, like Eitan, does not actually hold a JD. And I think he's the first commissioner in a long time to not have a JD. His background, he has an MBA. He started his career in the private sector, consultant. He was at McKinsey and also some financial startups. And then he's been at a number of government agencies. He got his start in the Treasury Department, helping to set up the CFPB. Along with Eitan, he was a founding member of the CFPB and ran the student loan portfolio at that agency. He was then at the Department of Education for a while as an advisor to the secretary. And now he is, of course, at the FTC. My fun fact sort of is also about how we met. Chris Chopra joined the FTC, of course, in the spring of 2018. I joined at the same time. I moved to DC to work for him at the same time. But I actually met the commissioner about 7 years earlier when I was at the Illinois Attorney General, and he was at the CFPB, and he was corralling states all over the country to take on for-profit colleges. There was an explosion in for-profit college predation during that period. And sort of, I know people think he writes a lot of statements. He did then too. He used to send around, model consent decrees and memos to all of the states, pushing us to be sharper in our investigations and in our enforcement. And that's how I really got to know him, is trying to work with him from Illinois, but working with him in DC to take on an industry that was harming a lot of consumers. And I can say more about this, but that experience has definitely shaped his outlook on his job.
That's wonderful. Thank you. And we will definitely return to that theme of Commissioner Chopra's statements in a few minutes. Bobby, tell us about Commissioner Wilson.
Thank you. Thank you for having me and for the folks who are tuning into this event. So Commissioner Wilson has been practicing law for over 25 years, and she was in private practice and in-house. She does like to refer to herself, though, as an FTC recidivist. She was a summer law clerk in BC, and then she was chief of staff for Chairman Tim Uris. And so this is her third stint at the FTC. But in between that, she was at Kirkland and O'Melveny, and she had an extremely complex and robust antitrust practice representing Fortune 500 companies. She is deeply steeped in antitrust law and policy, is a much sought-after speaker. But she also worked in consumer protection and private practice, representing clients. And since joining the commission, she's had a bit of a focus, obviously, on everything, but a little bit more on privacy, and really has done a deep dive into the issues, so much so that there was a recent MLEX article that dubbed her the face of privacy at the FTC during the pandemic, because she's given a bunch of speeches and written a bunch of articles on that. One thing she would probably like me to say about her background is she is a firm believer in free markets and believes competition benefits consumers and overregulation stifles innovation and competition. So fun fact, first of all, Commissioner Wilson is an extremely fun person. I think the other attorney advisors can agree on that. She's just an incredible boss and a wonderful person to work for. And she's also a bit of a daredevil. So several years ago, she was watching the X Games with her daughter, and they got inspired, and they pulled out the skateboard ramps, and they were going on mountain bikes, and she was trying to get like big air and doing almost a full backward somersault on the ramp. Unfortunately, she fell and crashed her knee. But that did not stop her from recreating the X Games the very next year and trying to do it again. But thankfully, I think she's retired from that, and she's focusing on being an FTC commissioner.
Thank goodness my 7-year-old isn't listening to this, because you're giving him ideas.
You're giving me ideas too. Yeah. Well, those are great facts. Thank you. I want to spend a little bit of time talking about enforcement generally, and we have some questions on that. But I'm going to start off. I'd like to hear from all four of you. Austin, we'll start with you on this one. But why don't you give the audience a little bit of a insight into your boss's consumer protection enforcement priorities? For example, are there specific types of conduct or specific types of industries that the commissioners are focused on? So, Austin, you want to kick this one off?
Happily. I think you'll find a lot of consensus across the different commissioners in terms of priorities, but I'll just speak to Becca's right now. She's particularly interested in vulnerable consumers and marginalized communities, and so that includes children, communities of color and low-income communities, our veterans and military communities that often are targeted by scams. What we've seen with the COVID crisis is also what we see with consumer protection issues, including privacy, which is that we live in an unequal society and these harms fall in unequal ways. And so she's always interested in looking at enforcement cases that can provide the biggest bang for the buck in terms of consumer redress and deterrence to make sure that our markets are working well for consumers. She's particularly interested in terms of industries in problems that are coming around the corner. So, something that might not particularly interest her is problems that were prevalent in the 1970s and have mostly petered out by now. But especially when it comes to online commerce and major privacy questions of our new digital lives, she wants the agency to be looking forward and trying to anticipate where those harms are coming down the pike.
Thanks. Bobby, you want to give us a little bit of flavor into Commissioner X Games?
Oh, she'll love that. I would say privacy and data security are priority consumer protection issues for Commissioner Wilson, and with a particular focus, which she shares with Commissioner Slaughter, and they've actually done some panels and speaking engagements together on children's privacy and the privacy of sensitive health information. Those are two big issues for her. She also really strongly supports the agency's fraud program that targets companies, engaging in conduct that causes substantial injury to consumers. And she's been really supportive and proud of recent efforts by the agency. We've had, whole divisions and parts of regions pivot to focusing on COVID scams and have brought a bunch of cases. And she just wanted me to give a shout out to the staff that they were able to investigate thoroughly and prosecute and bring these cases, from home with children underfoot, homeschooling, and just doing such a great job on that. And so that's an area of priority and focus for her right now.
Great. Eitan, how about Commissioner Phillips?
So I think as what Austin said is the commissioners probably broadly share a lot of the priorities. But for Commissioner Phillips, he has a particular fondness for the, let's say, unsexy bread and butter fraud and scam cases that have a real, tangible, direct impact on people's lives. And, I think one of the things he's talked a lot about in testimony and speeches is that despite the fact that there's a lot of, hot new cases, there's privacy, there's data security, there's online commerce that are all very important, he doesn't want to get lost in the mix, the important work that the agency and the staff are doing on those kind of cases. Along with those, and I think related, is he has a particular interest in pyramid schemes and the MLM market and what's going on there. And our caseload there. We've, for those who are paying attention, we've recently brought a handful of additional cases in that space, and I think it's another area that he has a real interest in. In terms of industries, I don't know if there's industry focus, but within the world of scams, I think he has a particular focus on scams related to health, where people are convinced to go after and go out and take some miracle cure. In those cases, you don't only find consumers' financial well-being at risk, but their health as well, as people often will, ignore the advice of their doctors and medical professionals and go off and take some pill that they think is going to cure them or undergo some treatment. And we've had a number of those cases. And for him, I think those are the kind of bread and butter, real impactful, tangible cases that he really wants to highlight in terms of the great work that we do.
Okay, thanks. And then Sam, how about Commissioner Chopra?
Sure. Well, I alluded to earlier the fact that his experience is heavily shaped by his experience, and I can say the same thing for myself, with the financial crisis and with the explosion in student debt that followed it. And what he saw, especially in the run-up to the financial crisis, was federal regulators and enforcers, including this one, doing very, very, very little to focus on major companies that were defrauding millions of people, instead sort of chasing fly-by-night operators while turning the other way when companies like AmeriQuest and Countrywide were defrauding millions. And after the financial crisis, he felt that federal regulators, especially criminal regulators, did very little to hold those bad actors accountable even after the fact. His perception was that Wall Street executives and others effectively operated under a separate system of justice than small-time scammers. So when he came to the commission, he circulated and published a memo, I think his first or second week, on how focused on repeat offenders and focused on how the FTC needs to make very clear that its orders are not suggestions, that it is willing to hold individuals liable if they broke the law, even if they worked at a large company, that it is willing to seek civil penalties that actually exceed a company's profits rather than allowing major firms to profit from breaking the law. And he made clear that the FTC needed to be more even-handed in its approach, going hard after scams by small-time operators, as we do, but also going hard when major firms break the law and cost millions of Americans their life savings. So, throughout his time at the commission, he has argued for more even-handed enforcement to ensure we're making charging decisions on an even-handed basis based on the facts rather than whether a company is large or small. In terms of issue areas, I would echo what most of my colleagues have said, but I would say he has tried to focus on areas where the FTC has a really unique role. Some of those include small business and franchise, where agencies like this generally small business lending, for example, millions of small businesses are being harmed by predatory lenders right now. That is outside FTC that is outside CFPB jurisdiction, and it's an area where the FTC can really lean in. Auto finance. The auto companies begged to be excluded from Dodd-Frank and to be under FTC jurisdiction instead, but we've done very little comprehensively to actually deal with major rise in delinquency and fraud in the auto market. Tech companies, I think everyone alluded, I think this is a priority for the whole commission about making sure that they are not gaining power and dominance at the expense of our privacy and at the expense of consumers. So there are a lot of sort of verticals that he is focused on, especially where the FTC can play a unique role. But across the board, what he wants to make sure is that we are an active, effective regulator that will hold entities accountable regardless of whether they're fly-by-night scams or Fortune 50 corporations.
Great. Thank you for sharing their priorities with us. is it your sense, Eitan, I'll start with you, and others feel free to chime in or not. Is it your sense that that staff are taking their cues, both in terms of investigations and the relief the commission's seeking, from what they perceive to be the commissioner's priorities, or is it staff taking what they believe to be issues to the commissioners themselves?
So I'm actually really interested to hear what everyone else here has to say. We have not rehearsed this, so I honestly have no idea what people are going to say. And I think, for the benefit of the audience, what we have here actually are, I would say, two insiders, Sam and Bobby, who've both spent time in the trenches of the commission, and Austin and I, who are a little bit more outsiders, having come from government, but without the same experience on staff. So from my perspective, the answer is yes and no. I think there are definitely priorities that are advanced by individual commissioners, and sometimes the commission as a whole. For instance, I think the commission has talked a lot about online endorsements. And I think staff does take those into account. But on the other end, I think the answer is in some ways no, in that few, if any, of the commission's particular priorities, I think, are really surprising. I mean, is anybody out there surprised that this commission has a focus on privacy and data security? I don't think that's not going to be a surprise, and that's something that's shared by the commission and by staff. So to the degree that it's influencing cases, I think it's not a wholesale change, and it's probably more influence on the margins. The other thing I would say is that I think to a large degree, the cases that staff are investigating to some degree or to a large degree influence the commissioners, because when the commissioners see the cases that staff brings up and see the issues that staff are flagging, I think that ultimately influences and can help the commissioners focus on what problems are out there in the market that they need to be paying attention to.
Yeah, I mean, I guess that kind of goes to the basic principle that I think most of us, certainly on the private side, tell our clients is look, staff are consumers too. They see the same things, that others do, and if they see something in the market that's not right, they'll investigate.
I completely agree, and I really appreciate.
Absolutely. Ahem. Okay, here I go.
Sorry, Siri's our third.
Our fifth panelist is Siri. I really appreciate, Eitan, the outsider versus insider distinction that you made. Dan and I being on the outside looking in, when our clients receive a CID or just an access letter or something and they're under an investigation, we have to counsel them. And usually the question we get is, where did this come from? How did it start? And sometimes the answer is, well, it could be consumer complaints. It could be the Sentinel. As Dan said, staff listened to a radio spot that they didn't like, and off it went. But it's also good to know whether they're sort of reading tea leaves from up on high. So we appreciate that distinction.
I'll add one thing.
Oh, sure.
So I'll add one thing is when I was at the CFPB and people asked me that question, I often said one of the best sources for CFPB investigations was the LA Times, who had a great consumer beat reporters and flagged a lot of issues. So they can come from anywhere.
Bobby, you were going to jump in there.
Yeah, I was just going to say, picking up on Eitan's point, having been, on the other side, the staff person, one thing that cannot be overemphasized enough is how small an agency we are and how limited our resources are. And we essentially have jurisdiction over the entire economy. So, I mean, there are those carve-outs, nonprofits and the like. But so the staff has to make very difficult decisions about areas to investigate. So, and they have to set priorities and determine program areas. And so, of course, they're responsive to the priorities of the commissioners. But as you said, Eric, they get complaints from Congress. They get consumer complaints. There's Sentinel. There are industries that staff monitors on a regular basis. So investigations can come from, a huge variety of sources. But certainly, if the commission, a majority of the commission says to the staff, we don't want to see these kinds of cases anymore, or we really want to see more of these cases, your bureau directors and your associate directors are going to pay attention to that.
Sam or Austin, do you have anything to add?
Just one observation that's less about what kind of cases get ginned up and more about the scope of each investigation, really, no matter the industry or type of law violation. I think it used to be the case that when there was a kind of smoking gun, red flag piece of evidence of a CEO's personal participation in a law violation, that the staff would then write up a justification for naming that individual. But otherwise, it just was a standard practice to describe the company that had committed the violations and not go in depth as to the question of whether there might be individual liability from corporate executives. Commissioner Chopra and Commissioner Slaughter published a statement, a joint concurrence in a case called Musical.ly, which was the predecessor to TikTok, emphasizing the urgency from the two of their perspectives of not naming individuals no matter what, but of always investigating the possibility of individual liability as an important part of the commission's enforcement program. And I think, some of that push has been seen in the outcomes of cases. There are a number of active litigations right now in which individuals have been named who are very powerful, Fortune 500 CEOs. And in general, I do think that in this case, the interest of these two commissioners, as expressed in that statement, and I think a broader consensus on the commission that individual liability is an important aspect to our investigations, has led to a greater emphasis on the part of the staff when conducting those investigations and when explaining to the commission why or why not the recommendation was to name an individual in a particular matter.
Yeah, I'll be very quick. I agree with most of what's been said. All I'll say is I was pretty new to the FTC when I joined Commissioner Chopra, and the advice I got from veterans who will remain unnamed is that I should make sure he's a rubber stamp for any recommendation that comes through BCP, that I should get him to yes, was the advice. And, that has not happened. The reality in this agency is that staff has a lot of autonomy. And I think that is a really good thing, because it's allowed us to recruit really outstanding attorneys who could be making a lot more money elsewhere, who are really passionate about their work and do a really great job on cases. I think the downside is that you see less strategic direction from the Bureau or from other agency leadership in key sort of emerging areas, for example, that may be cross-cutting across consumer protection and competition, or that may be cross-cutting across divisions within the agency. So, I think the level of autonomy staff has is very important and is great, but we also need to make sure that leadership is active to make sure that our enforcement priorities are not ad hoc and that we're thinking strategically and, as Austin said, looking around the corners to see what's coming down the pike.
So talking about what's coming down the pike, Eric and I and our colleagues and other members of the FTC bar, at least on the private side, have noticed staff tending to take a harder line approach during consent negotiations as to the amount of equitable monetary relief. First of all, do you think that observation is accurate? And if so, is this a phenomenon that's being driven by individual commissioners? Sam, you were just chatting. Let's keep this conversation going. What do you think?
Well, I hope it's accurate. When Commissioner Chopra and I started in 2018, we were seeing a lot of proposed orders, even in cases of blatant fraud, that simply ordered wrongdoers to not break the law for a second time. And people said, well, that's going to deter the wrongdoers from breaking the law a second time. But it's like, we're a federal agency. We bring a small fraction of the cases that are out there. We can't just be thinking about specific deterrence. We need to be thinking about general deterrence. We have 300 million consumers to protect. So, my boss has argued very strongly that, especially in cases involving clear dishonesty, we're not talking sort of novel forms of misconduct, no money orders don't make sense. They do nothing to redress victims, and they do nothing to deter others from engaging in the same misconduct. And, what I found interesting as I've been in this job for a little while is that this really is not a novel idea. If you look back to the 1960s, when the FTC came under heavy criticism from people ranging from Miles Kirkpatrick and the ABA to Ralph Nader to Richard Posner, there was widespread consensus at the time that no money cease and desist orders were extremely ineffective. Walter Magnuson of the Magnuson-Moss app called them slaps on the wrist. Bob Pitofsky at the time said they were scandalously weak. So, there was once a consensus, at least an apparent consensus, that for cases of clear dishonesty, we were not going to just tell a lawbreaker, you get a second chance. We were actually going to make sure they're held accountable. That consensus maybe has frayed in the last 4 decades as the commission's makeup has changed. But I do think, or at least I would like to think, that in the last 2 years, I think there's greater recognition of the harms that stem from under-enforcement and under-deterrence. And I'm curious what my colleagues think.
Yeah, I was going to say that seems, you've basically just restated Commissioner Chopra's statement in the Sunday Riley case.
And in other cases as well.
Yeah, and in other cases as well. And Austin, I know that your boss joined Commissioner Chopra in that as well. But point taken, love to hear what everyone else thinks about this as well. Austin, I mentioned you. Why don't you chime in?
Sure. I think, as you noted, Commissioner Chopra and Commissioner Slaughter have often spoken with one voice about this. And the specific versus general deterrence point that Sam made is a crucial one. And no money orders maybe don't even specifically deter very much, because you still have a relatively low risk of detection when we don't have supervisory authority. We're just depending on the paperwork they send in, to be honest. And these are companies that in many cases have shown themselves not to be so honest. And, the staff takes a critical eye to the reporting obligations for companies under order, but we do not bring many order enforcement actions. There are some, and there are some that are very large. One was recently for $5 billion. There can be very serious consequences, but the fundamental flaw with Section 5 not providing civil money penalties on first-time violations is that we don't get that many bites at the apple. And so shifting our framework toward general deterrence, I think, has been a really important push by the commission. And that is why you'll see the staff that, staff put in tons of time on a particular investigation, and they want to get 3 votes. They want to get 5 votes, ideally, but they certainly don't want to see all of their hard work not pay off in the end. And, a recommendation for a settlement from the staff, Commissioner Slaughter says this often, is necessary, but it is not necessarily sufficient to get her vote. She wants to weigh these important countervailing benefits about additional staff time or the possibility of litigation risk against what she sees as an urgent need for more general deterrence. And, the equitable monetary relief section of the settlement is an important aspect of that. I know it's important to your clients, but she's also interested, as I mentioned, in individual liability and other forms of important redress, like consumer notice, which is a tool that I think we've not used as aggressively as we could. And so there are many aspects to this, and she doesn't have a formula. There's no magic threshold you can hit to get her vote on the settlement. They're all, analyzed individually, and but she wants to see a good bang for the buck. The FTC is a great investment for taxpayers, and she wants to be a good steward of that investment. We return a lot of money to consumers, and I think our consumer redress program has been really strong, although it is obviously existentially imperiled, as I think we'll talk about momentarily. But she does want to see more general deterrence. We live. The online world is the Wild West, and nobody's afraid of the sheriff right now, and we need to make a change there.
Thank you. Bobby and Eitan, you want to, I don't know who wants to go first, but you might have other views or not.
I can go. I mean, going back to the question that was posed, I can't say whether, staff taking a harder line on money, whether that observation is accurate because, there are so many different settlement negotiations going on all across BCP. What I can say is Commissioner Wilson certainly has a different view than Commissioners Chopra and Slaughter, particularly on the effectiveness of non-monetary relief. And myself, having been an attorney in the Enforcement Division, who, the Enforcement Division, every single order, district court or federal, that is entered by the agency goes to the Enforcement Division, and there is a staff person assigned to review the compliance report, and that review is not just checking the paper that they turn in, but there is a lot of independent investigation and review that goes on. In addition, I think Commissioner Wilson would submit that the non-monetary relief that is in many of our settlements has, significant effects on companies. I mean, let's remember that our privacy and data security orders are primarily non-monetary orders, and they require a comprehensive privacy or data security program, which often requires companies to, overhaul their privacy and data security, hire additional staff, pay for third-party assessments. So there are significant costs to the injunctive provisions in the order. And, even in cases where, it doesn't require that kind of huge structural change, you will see, ripple effects in the industry after an FTC order comes out, and companies and law firms like Venables holding webinars about, oh, the FTC just announced this order. Here's how to comply with what they're saying Section 5 says. So, the idea that they have no effect on the market generally or on the company specifically, I think Commissioner Wilson would take issue with that. That's not to say that she believes monetary relief isn't appropriate in some cases, but she does not necessarily believe that we have to be pushing for monetary relief in every single investigation, and that there is value in settling cases and freeing up staff to move on to other enforcement priorities. Again, hearkening back to limited resources, effective use of taxpayer dollars, and being a careful prosecutor and thinking really strategically about how to leverage and when to litigate to try to get money or push for individual liability or any of this other relief, and when to take a settlement that gets a company under order, subjects them to civil penalties, subjects them to compliance monitoring. As Venables knows, the compliance monitoring provisions and orders require companies to produce documents in 2 weeks regarding their compliance with the order, allow, interviews with employees, and all sorts of powers and authorities that it's not supervisory authority like you have over the banks, but it is significant, monitoring authority that the Enforcement Division uses all the time. So I go on, but I think I've...
It probably won't surprise you that Dan and I, who live in the dark side of the world, also wouldn't necessarily accept the premise that monetary relief is the stick, but not conduct relief. Sometimes you counsel your business clients, and you get to a dollar figure, but explaining to them some of the non-negotiable scofflaw provisions of orders, and just we're paid a lot of dollars per hour to tell people this is boilerplate. There's nothing we can do about it, and you're stuck with it for 20 years
against the wall. Right?
Is a bit of a challenge, but we don't want to leave you out of time.
Yeah.
So I'll be brief. I will say I think Commissioner Phillips shares a lot of the views that Bobby just expressed. That Commissioner Wilson feels. Two points. The first is it was the order enforcement was mentioned a couple times. I think personally that the limited amount of order enforcement is in fact a reflection of the fact that our orders tend to be successful. That companies, having been slapped and there are consequences. I think a couple people have pointed out that having been slapped are in fact getting in line. Not everyone, and we do bring order enforcement cases, but that, by and large, we don't bring that many order enforcement cases because the orders are working. That's point number one. Point number two is there's something that the Commissioner Phillips said pretty early on and I think was joined by Commissioner Wilson in a case called iSpring, where the short version of a much longer statement is just because we can doesn't mean we should. Just because we sit as federal regulators or federal law enforcement agency with a lot of power over a defendant who is trying desperately to settle a case, and I'm not just suggesting that anything is done that's inappropriate, but we have to take that authority and that leverage very carefully and thoughtfully. And in cases with monetary relief, we need to think carefully about what the appropriate relief is. And the answer in many cases is putting aside the issues that Bobby mentioned about resource constraints and time, which are very, very real. Is there a number that we get to that we think is a real appropriate number? And that's not always going to be the case. And just because we can, to a sense, impose our will and demand the money doesn't mean that's always the right thing to do. And I think that's one of the approaches that he would take when thinking about monetary relief in a lot of cases.
Okay, thanks. This is actually a great place to pause for a second. We're about halfway through. For those on the phone, the CLE code, which we'll also announce at the end, but I'll announce it now, is Fireside, all one word, FIRESIDE. So with that little interlude, why don't we keep this discussion going? We've got your boss's views on equitable. Somewhat, we've got some of your boss's reviews on monetary relief. We know that Commissioner Chopra is in favor of a policy statement on monetary relief in deception cases. What do the other commissioners think of a policy statement? Bobby, why don't we kick it off with you?
Commissioner Wilson hasn't actually publicly stated a view as to whether the commission should issue a policy statement on monetary relief in deception cases. I mean, for her, she evaluates monetary relief in any given matter based on the facts of the particular case. She would say it's very fact specific, and the analysis presented to her by staff, both the attorneys and the economists. Commissioner Wilson in particular is always extremely interested in economic analysis. And, she looks at the precedent. I mean, we do have case law on when we have authority to get monetary relief, which, as we'll get to, is changing daily. The case law.
Literally. Okay. Austin or Eitan, you want to chime in? Sam, I think we know what Commissioner Chopra is saying.
Austin, you want to go or should I go?
I'll just jump in to say, I think she would be inclined toward a strong policy statement, and the strength of policy statements also depends on the extent of consensus. It can be useful to put out a policy statement that does not achieve consensus on the commission when it still is a pretty clear direction to staff about what a majority of the commission thinks. But this is an important aspect of our enforcement program, and as you're seeing in this conversation, it might not be possible to get to a consensus, but she's always willing to try.
So I'll add, and this is maybe jumping off what both Bobby and Austin said. I think the question is, what does this statement say? And I think there is going to be some disagreement. And this reflects a little bit of our previous conversation. For instance, how do we factor in harm in thinking about equitable monetary relief? And more importantly, in cases where harm is either difficult to figure out, or in many privacy cases where tangible harm is maybe not even existent. How do we factor in the considerations Supreme Court looked at in lieu in terms of joint and several liability or profits? What presumptions do we use to determine which consumers were deceived or were impacted? How do we avoid consumer windfall? How do we balance compensating consumers with making sure that companies that are not fundamentally frauds are not ultimately put in a position where they have to go out of business. So these are, I'm not saying that there are not answers to these questions, but these are complicated questions. I think that there's not necessarily agreement on a lot of these issues and how they would play into a statement. So while I think the idea of a statement is a good one, I think maybe this is what Bobby and Austin were both saying, nailing down the details of a statement, I think may prove quite challenging. And this is, by the way, only talking about equitable monetary relief, putting entirely aside civil penalties, which is a whole other Gordian knot to untangle. That's a completely separate question.
Yeah, that's a good distinction, and let me transition then into talking about equitable monetary relief. And as Bobby said, this changes daily, and it changed yesterday. And so I'm not sure if all of you have had a chance to review, but yesterday the Third Circuit joined the Seventh Circuit in holding that under Section 13B, equitable monetary relief could not be awarded. And that was a case decided, like I said, yesterday and called FTC versus AbbVie. The Seventh Circuit case, Credit Bureau, is pending before the Supreme Court right now. And I'd love for you guys to give us your thoughts, or your boss's thoughts, excuse me, on whether, Credit Bureau will, certainly while it's pending, but, will it chill the Commission's attempts to obtain equitable monetary relief in Section 13B cases, and then should the current 13B cases be stayed pending Credit Bureau? I have a feeling you probably can't weigh in too much on the second question, so we can probably stick with the first one.
Well, no, I think we actually can. So, I mean, look, the Supreme Court's docket for the 2020 October term includes what is functionally a nuclear detonation device for the Federal Trade Commission's ability to deliver redress to consumers who were harmed, and that's wrong. The statutory argument is, I think, one of these, so simple. It's injunctions involve putting people back in a position that they would be in without the law breaking, and I think that includes monetary redress and disgorgement. Regardless, our Office of General Counsel will make those arguments, and not the Solicitor General of the United States, which is its own problem. But in terms of the Commission's ongoing enforcement work, I think we're full steam ahead. There's no reason for us to stop trying to get redress for consumers, until the day that the Supreme Court tells us we're not allowed to. And then on that day, I think the United States Congress, regardless of the outcome of this election, will come together in a bipartisan way and say, of course, we want the Federal Trade Commission to be able to get money back to consumers who were harmed. So I think whether this gets resolved at the Supreme Court, which who knows what it'll look like by the time these cases are argued and decided, or whether it gets resolved in Congress, the Federal Trade Commission's ability to return money to consumers is the most popular thing imaginable in government, and we'll find a way. And in the meantime, I don't think that the lack of certainty is impeding us at all. We're trying to get that money for consumers. Our settlements are just as strong. Our district court judgments are just as strong. And even though now we've lost a Second Circuit to this hyper-literalist misreading of the word injunction, we're going to proceed and keep fighting to get the best outcomes we can for American consumers.
Sam, Eitan, Bobby, you want to add to that or have different thoughts?
Sure. Go ahead, Sam.
Go ahead, Eitan. Oh, I was just going to say, I agree with what Austin said. I mean, I'm very concerned about 13B. It's a vital tool. I hope the Supreme Court gets this right. But one of the arguments Commissioner Chopra has been trying to make for a while now, both internally and externally, is we need to be prepared as an agency for a scenario in which we lose this authority. Even as we continue to go full speed ahead with it, we need to just we need to be planning for these contingencies. I don't think, he is not confident. It took us many months just to get SafeWeb reauthorized, which didn't happen until last week. He is not confident that we're going to get this 13B fix suddenly from Congress. And what he has argued is that we need to be doing three things in particular to prepare for the day that, if the day comes, that we lose 13B. One, we need to restate basic legal prohibitions into rules so that we no longer need 13B to get monetary relief. I am not talking about sort of 1970s style rules that require companies to fill out paperwork and get acknowledgments and all. I'm talking about simple rules, and Section 18 of the FTC Act allows it, that prohibits common types of misconduct, like what we're doing for Made in USA. We had guidance on Made in USA for a long time. Now we're simply turning that guidance into a rule that says you can't make Made in USA claims unless your products all are virtually all made in the US. It imposes no new obligations on anyone in the industry, but it ensures the FTC has a plan B, has other weapons in our arsenal in case we lose 13B, that we will be able to seek civil penalties in Section 19 relief. So one is codifying rules that don't impose any burden on market participants, but that protect us in the event we lose 13B. Two, partnering with state enforcers. We're not the only UDAP enforcer in town. There are 50 plus other UDAP enforcers. And I have seen my boss say in party meetings, and we've talked about this before, when we hear from law firms, oh, you're going to lose 13B, you should settle this now. He has said, I will call an attorney general tomorrow, and we will have a co-plaintiff by next week. And that's what the FTC needs to be prepared to do. All of these AGs have very clear authority to get monetary relief. The FTC has a good track record in a lot of areas of partnering with states, but we need to be doing that more strategically, he believes, across the board. So that's the second. The third is taking advantage of a provision, the Penalty Offense Authority under the FTC Act, Section 5M1B, which we have not used. We used it about 10 years ago, but for the most part, we have not used it in decades. And what that tool allows us to do is it says that companies that are on notice of conduct the commission has condemned in previous orders are liable for civil penalties if they violate, if they engage in that conduct. Chris Chopra and I are coming out with a law review article in the next week or two that'll show, I hope, how the commission can act almost immediately in industries across the economy to trigger civil penalties and Section 19 authority in new areas without any additional legislation from Congress. And irrespective of where the Supreme Court goes on CBC. So those are kind of the three key ideas. But the big thing I want your audience to know is that we have other tricks up our sleeve. We have other tools in our arsenal. We have to get going on using them. But losing 13B will not be the end of the FTC's ability to hold wrongdoers accountable if we're willing to use the tools that Congress gave us.
Mm-hmm. Yeah, I wouldn't even call them tricks. I mean, they are tools, and they are well known to anyone who practices and known to our clients as well, at least the clients who ask. And that's not to say that, as Austin said, one of the returning money to consumers who are harmed is, people like that, right? The plaintiffs bar does as well, and AGs, to your point, Sam. They can do the same without worrying about 13B. So this isn't, it might be the end. It could be the end of one avenue, but it's not the end of, an entire neighborhood. Eitan or Robin, do you have a view that you want to share, or are they covered?
I'll just make two quick points. The first is, I think I am putting aside the merits of the case, of the argument. I think I'm a little less optimistic perhaps than Austin. About whether we will in fact succeed in the Supreme Court. I think that it feels like the winds are maybe blowing the other direction. And the second is, and I think Austin, alluded to this, is, and this is something that I recall, when I was at the CFPB, and we would talk to defendants about potentially bringing abusiveness cases, and their response is, well, we'll challenge that in court. And the general response we had there was, we lose every case we don't bring. And I think that is true here as well. I think that when we get briefs or papers from potential defendants basically arguing, dismiss this case or we're going to challenge you, that doesn't really fly because, if we lose, we lose, but we've lost if we dismiss. And I don't think the staff or the commission fears going into court if we have to. And I think that's true broadly, but I think on 13B in particular.
Okay. Bobby, you want to round out the conversation on that? Or or have we covered it all?
I just want to add one small point, which is, I take Sam's point. Good news is that Senator Wicker did include a third fix in recent privacy legislation that he introduced, and the commissioners all did testify before Congress, asking for this, and is working to provide technical assistance to Congress. So to the extent it goes south, know that we have an Office of Congressional Relations with excellent relationships on the Hills. So, in terms of in the direction that Commissioner Chopra has outlined and start utilizing these other tools, there are multiple tracks that the commission can be operating under to preserve the ability, as Austin says, to give money back to consumers and make consumers whole. The decades of case law that have said that when you confer on an agency equitable authority that includes the full panoply of remedies really seems to be the correct interpretation, but we will see what happens in the Supreme Court.
Okay. I'm going to turn it back over to Eric to talk commissioner meetings. I want to make sure we have a lot of time to address that because I know our audience will be interested in that. We do have an audience question that we will get to at the very end that dovetails with the discussion we've just had. But Eric, you want to talk a little bit about the commissioner meetings and do's and don'ts and so on and so forth?
Absolutely. A highlight of anyone who's been through an FTC investigation. There are people who I imagine are listening to us right now who no one in our audience is a fraudster, of course, but legitimate businesses get CIDs and get investigated as well. And sometimes we find ourselves working with staff and maybe we're at an impasse. And, in order to resolve things, we have to go up the chain, as we call it, to the front office and then to the commissioners themselves. Sam, you made a point earlier about how staff has autonomy, and I take that point. I think I'm speaking for Dan. I'm certainly speaking for myself. Typically, I advise clients, FTC clients, that it is a bad idea to try to go over staff's head. It's just not received well from anyone in the front office, and you want to give staff the chance to do its job and write its memo before you go further. But, do we have any thoughts on, what happens when we're at an impasse? Is there any merit to trying to fast track commission meetings before all the T's are crossed? Do your bosses have views on that? Do you have views on that? Bobby, we ended with you, so let's start with you on this one.
Sure. So I just want to pick up on Sam's point about staff autonomy. And of course, I agree with that because I was a staff person for 25 years. But it's also important to remember that the staff does not operate in a vacuum. So if they have consent authority, that means that their assistant director, their associate director, the deputy director at the bureau, and the bureau director, and all the front office staff, they have all reviewed this matter and determined that there is reason to believe that the law has been violated. Sometimes these matters have even been previewed to commissioners. So you cannot just sue somebody if you are a staff person. You have to have taken this up the chain, and people are going to question you. And they're, on the issues of individual liability, people are going to ask to see those emails, from the CEO and see those documents. So the idea that, staff has this view that you violated the law that is just going to be considered unacceptable up the line is not accurate. So, for Commissioner Wilson, I will say there's very few circumstances where she would advise you to go over staff's head to meet with her. She has incredible respect for staff and the process. I won't say never, because there's always an exception to every rule. But there's a process, and she believes that, you should work within that process and then, try to get to as far as you can, right? Obviously, there's going to be barriers to settlement, and there's going to be a point where your client is going to say, no, I can't agree to this without talking to the commission. And then she is happy to engage and meet with parties, but she wants to have that process play out first in most cases.
Sam, what do you think?
I completely agree with everything Bobby said. I really have nothing to add.
I want to just
Awesome.
pop in with a procedural or kind of irrespective of the substance of the matter, just some tips. Please don't come to the FTC to meet with commissioners with an all-white, all-male attorney panel of 8 guys who all look the same. We've heard this from Bruce Hoffman, and Andrew Smith has said it. It's important for potential defendants to have diverse teams, and also let the more junior associates who are probably actually closer to the facts engage in the meetings. And then even beyond that, having non-lawyers, the business people at the table is really useful. Commissioners like to understand more about the business, and this is particularly true for Commissioner Chopra. I've sat in on a couple of party meetings that he's had where it almost feels like, he's like trying to puzzle together the inner workings of the board and how they think about things and their incentives. He's not going to get that from Venables, with all due respect to the excellent counsel you provide. Having the company, the business people there, I think, is the circumstance in which I've seen the most productive advancing of the conversation as between commissioners and the potential settlement or litigation to come. So those are my 2 pieces of advice. And you've already heard this one, but please don't tell the commissioners that you care more about the FTC than they do. That is not taken well. And that particularly has come up a lot in the 13B conversations. And even when there are, FTC recidivists on the other side of the table who really do love the agency, we know that. They don't have to say it 5 times in their presentation. So stick to the facts, make your argument, bring a diverse team, and if at all possible, bring in the deciders in the company, and let them make their case. I've seen some remarkably impressive presentations by CEOs, CFOs, the product managers. And in some cases, I have seen, especially when there's real contrition for an error that broke the law, that can move commissioners to say, this is not a take it to the mat case. We don't need to litigate up through the circuit courts on this. We can accept a reasonable settlement, in part because it changes their calculation as to specific deterrence. When they see real contrition from someone who's made a mistake, it makes it less likely that that person makes a mistake again. And that particularly can move the needle, I want to say, on the scofflaw provision duration. Commissioner Slaughter prefers the 20-year default on that, but she has voted in favor of settlements that involve 10 or 15-year scofflaw provisions, particularly when there's been a business case made that it's not going to happen again. And that case can be made very effectively in person. So those are some of my tips.
I can't tell if people can see me nodding, but I totally agree with Austin.
That was very useful. And Austin, you started to go where I think we were about to go in terms of the mechanics and the strategy behind going to a commission meeting. And these, what you started to very helpfully advise our audience is the type of questions that Dan and I and our colleagues get all the time, right? Who goes to the meeting? how many people, is it lawyer driven? Is it business person driven? I typically agree with your advice, and I tell clients they don't want to hear from us; they want to hear from you. I think there are exceptions to that depending on how well people present. Do you go in with a white paper? Do you go in with a slide deck? How long should it be? Will it actually be read? Is it read by only the four of you, or do your bosses read it? So can we continue this conversation for just a few more minutes and start with Etan, because just to round out the four of you?
Sure. There's a lot there, so I'm sure I won't hit on all your points. First, let me just follow up on what Austin said, and I think you reflect on that as well. Is one of the questions when thinking about bringing in management is how well they present. So I can remember a specific case when management came in early in my tenure at the commission, and the presentation ended up so poorly, and management was so ineffectual and so unable to explain their position that the entire commission ended up, I think they ended up bringing or all agreeing that individual liability should be on the table where it had not been previously. So I guess one aspect is both think about who's presenting, but also think about your client as if they're going in for a deposition, and prepare them that way, because they're going to, they need to be able to answer questions thoughtfully, carefully. These are very, very smart people, and you're not going to get one over on them because you're charming or because you've managed to, negotiate life that way. In some ways, I used to be a federal prosecutor, and one of the things that you learn as a federal prosecutor is, you go into a meeting with a witness. The witness assumes that you know nothing, but you know everything long before the meeting has started. You should kind of treat your meetings with commissioners in the same way. Assume that they have thought through the issues, and that you need to be very careful about kind of what you say and what you're presenting. In terms of white papers, yes, they are useful. Don't assume that all the other submissions that you've made to the commission or to the staff or to the bureau directors are all going to filter up. I'm not saying that they don't or they don't try to, but that ends up being quite a bit of paper. So if you have good arguments, put them in the white paper. Get the white paper in with more than 3 days notice. Get it in enough time for people to read it, digest it. Staff is going to want to respond, and that's appropriate because the commissioners rely on staff's advice. But the commissioners are also going to want to think about it and digest it. If you are putting forward legal arguments, this kind of goes to what I said before. Make sure they're real legal arguments. Don't look for that. And again, I'm speaking from experience here. Don't look for that one judge in some federal district court who completely misapplied the laws of the deception standard and then cite that in your paper for deception, right? If you're going to come in with a novel legal argument, make sure that it is well supported with both facts and law. In the presentation itself, just a couple more points. In the presentation itself, yes, I think PowerPoints are helpful, but not slavishly so. So again, I recall a presentation where someone came in with their PowerPoint. It was actually a very good, very effective PowerPoint. But boy, that attorney was holding on to that PowerPoint like it was a lifeboat. And every time the commissioner asked the question, they'd answer it and then go right back to that PowerPoint like they had to get through it. So the same way people kind of talk about Supreme Court arguments, go in with the arguments you want to make. But if the commissioners want to go down a certain path, follow them down that path. Be prepared to talk about that. Especially often the commissioner is giving you an opening. Sometimes they're going to interrogate you about something they have a concern about, but sometimes they're actually opening a door for you to explain something that they have a commissioner is concerned about, or perhaps commissioner has a concern about staff's approach to. So take those opportunities. Don't feel bound to the piece of paper or the PowerPoint that you brought in. And know that they will be read by the attorney advisors and by the commissioners. And then the last thing I would say is, if you are going into a meeting, I'll speak just for myself, and you want to reach out to the attorney advisor who's handling the matter and say, what does the commissioner care about? The answer in many cases might be, it's your meeting, you lead it. But in some cases, the answer is going to be, oh, the commissioner read your papers, or we've read them, and these are the 3 things that we think are really important. There's no point for us to hide the ball there. I am happy to share with counsel what things the commissioner would like to focus on. So pick up the phone, send an email, reach out. At least I'm speaking for myself. Others can speak for themselves, and ask. Because the meeting should be effective for everybody. And again, in some cases, the answer will be, it's your meeting, but in many cases, there'll be, these are the 3 or 4 things. And back to the original point, that might also impact who you want to bring, right? If there are marketing questions, maybe the chief marketing officer comes in. If there are financial questions, the chief financial officer. If we're really concerned about some of the economic models you're using, you may want to bring your outside economic consultant. So think about doing that, because I think that's going to make the meetings more effective for everyone. And frankly, if the commissioners are happy with the way the meetings went, as opposed to feeling they're a waste of time, that's just also going to, make the environment a lot better for settlement.
That was wonderful. That was a tour de force of useful guidance for our audience. Very much appreciated. I want to kind of put a bow around this conversation and then get to an audience question, which kind of aligns with what we were going to ask anyway. But just final thoughts, particularly from Bobby and Sam, because we've heard from Austin and now Eitan. We've heard that maybe contrition from the business person works. All your legal arguments are well supported. Just final thoughts, Sam and Bobby. What works well? What have you seen that just doesn't work? It's just not a good idea when we're coming in for commission meetings.
Sam, why don't you go and I'll end, but I definitely have some thoughts. So
yeah, I actually don't have a lot to add. I so agree. I mean, Eitan and Austin's counsel I thought was extremely wise, and it's 100% applicable in my office. Commissioner Chopra reads everything. I mean, he's a crazily fast reader and will have read the white paper and the staff memo and the staff bullets, and anything else we get, we will read. If attorneys reach out to me before the meetings, I will speak to them and share what he is interested in. I'm totally open door about that. Nothing to hide. Happy to do it always, assuming I have something to tell, but I'm always happy to take the call. And yeah, sort of echoing what Austin and Eitan said, these games about, well, back when I was at the FTC, we did this, or you're going to lose 13B, or you don't have a case and you're going to get it dismissed. I know my boss he believes we have outstanding litigators at the FTC, and he's very deferential to our staff when it comes to advising him on what the risks are. What he wants to hear from companies is, what went wrong? What did you do to fix it? How did you discover there was a problem? What actions did you take when you discovered that problem? Who, if anyone, was let go? What processes have you put in place to ensure it doesn't happen again? What levels of engagement have there been by a compliance committee on the board or similar oversight bodies? Those are the kinds of questions he wants to ask to ascertain how much of a need there is to really come back hard, or to make a determination, as he has in previous cases, that this is a company that made a mistake, that's cleaned it up, and that we just need to sort of reach a reasonable settlement and move on.
All right, Bobby.
hi. So as Sam said, I agree with, probably everything that all of my colleagues have said, and really great advice. On white papers, just for Commissioner Wilson, she absolutely finds them extremely helpful. Like Commissioner Chopra, she is a voracious and fast reader and reads everything. And so be prepared to get a question about the footnote on page 25 of Appendix E. So, you prepare for these meetings with Commissioner Wilson. But it's also fine with her if you submit a white paper to the Bureau, if you submit the same one with this Chopra letter that says, here's what's happened since. You don't have to write a completely new white paper for her, but she's gonna read it. In terms of bringing parties, she also really likes to have the business people there, but having been outside counsel, she knows that sometimes your business people are not the people that you want at the meeting. And so sometimes she will actually say it would be helpful to talk to the business people. And if you don't bring them, that might not be such a great idea if she specifically requested it, but on the other hand, if you know that this person is not going to present well, then you're probably acting in the best interest of your client, not bringing them. In terms of don'ts, I'll tell you two little stories that were really big don'ts, which is similar. It may be the same case that Eitan's talking about, but a counsel said that they really wanted to get through their presentation and to please hold all questions to the end. And so then the commissioner asked a question, and counsel very tersely answered the question, and then said again to the commissioner, And as I requested, please hold all questions till the end, and then went back to the presentation. The commissioner tuned out at that point. I mean, if this council wasn't going to engage, then the commissioner wasn't going to listen. And so that was really ineffective. Another council actually not just brought up some obscure case from a court, but said we lost a case where the district court had ruled against the FTC on a motion to dismiss, but that was appealed and reversed, and the case was in litigation. And so the FTC and misrepresented that case to the commissioner. And so staff jumped in and said, excuse me, that decision was reversed. And what was amazing was that I heard later that this council went on and did that same thing in every single commission meeting. So misrepresented to every single commissioner. That is a big no. First of all, the staff knows the case law, and also it's just a big no. Another thing that's not a great idea is when the commissioners are explaining the problems with the marketing or the substantiation, to profess extreme surprise that you had no idea that this was what the commission was concerned about. You know, the commissioners know that you've met with staff multiple times. You've tried to negotiate a consent. You've met with the associate directors. You've met with the bureau. You've been presented with a complaint that details the allegations. So acting like you had no idea that, you know, these claims were unsubstantiated, or the way that you disclosed your privacy policies was misleading or deceptive, it's disingenuous, and it's not going to be super helpful. And then the other thing I would say with Commissioner Wilson is she is very, very interested in empirical analysis and data. So to the extent you have economic analysis, or, you know, you've engaged with an economics firm, an economics consultant, bringing those individuals and presenting that analysis to her, she would actually find that very useful.
Ask a question.
Sure. Thank you all.
If I could just pick up on one thing Bobby said before we get to the next question.
Please.
I think some council and parties imagine 5 hermetically sealed hours of engagement. And what Bobby said about, you know, we know what happens in the other meetings. First of all, staff are in all the meetings. And so this seems so obvious, but I'll have to say it because it's happened. Don't say one thing to a Republican commissioner and then a different thing to a Democratic commissioner and assume that they don't talk, and figure out that you've been speaking out of both sides of your mouth. That is poor form. The 5 of commissioners and all of their staffs, as I hope you can tell, we all like each other. We work well together. We whisper to one another. It happened, I think, more when we were all at headquarters than it does today, where we have to call. But we communicate very well. And so there should be consistency, even though there will be differences in terms of the commissioner's interests in any particular meeting. You should not say 2 different things to 2 different commissioners and assume that it'll stay that way and hermetically sealed off in those meetings.
Very, very good advice. Thank you, all of you. Dan and I wanted to talk quickly about rulemaking, and it just so happens that we have a question from the audience also regarding rulemaking. So we'll just adopt that question as our final one. And the question put to all of you is basically, what are your boss's views on FTC rulemaking on the BCP side? You know, what are some key policy considerations prior to engaging in rulemaking? Is Magnuson-Moss rulemaking kind of a stumbling block? You know, obviously, we as we in our audience know, there's some rules under review right now and sort of constantly. But in the time we have remaining, could you share your thoughts, please? We'll start with Sam.
Sure. So, I mean, I think there's a mythology around FTC rulemaking, and Commissioner Slaughter's office has done some great work looking into this. We have as well, but we've certainly benefited from their work. There's this mythology that I was told when I joined the FTC that we don't do rules, that we can't do rules. Well, actually, we do rules, and we can do rules. We have and Section 18 gives us guidance on how to do it. Well, let me actually back up. First, we have a lot of APA rulemaking authority we just have chosen not to use. We have total rulemaking authority over the auto market, have never used it. We have some privacy rulemaking around energy privacy. We've never used it. Until this year, we had Made in USA APA rulemaking authority. We've never used it. So we ask, we're always seeking APA rulemaking authority. We don't always use the APA rulemaking authority we have. Commissioner Chopra feels strongly that when Congress had signaled that there may be widespread problems in the market where a case-by-case enforcement approach isn't necessarily effective, that we should be at least evaluating whether using the tools Congress gave us makes sense. With respect to so-called Mag-Moss rulemaking under Section 18, I think the question speaks to sort of what to look for. What we need to find is prevalent, unfair, or deceptive practices across the market. And especially given the 13B risk, Commissioner Chopra feels strongly that we should start initiating rulemakings, not to impose wild new paperwork or other obligations on businesses, but to simply restate existing law, like we did in Made in USA, and I'll give you one more example. We have these endorsement guides that we've had for many decades. They're good. They're really good. They're under review now. We're going to update them. But they're not binding on anyone. So when you have cases like Sunday Riley or other cases involving misinformation, you have sort of 13B questions about what the monetary theory is going to be. If we simply issued a rule that said it is a deceptive practice to endorse a product without disclosing your material connection to the seller, which is, by the way, the theory we use against fake reviews and fake likes and all these new misinformation practices, we can wipe out the 13B problem completely and seek real penalties against companies that cheat like this. And that's sort of Commissioner Chopra's approach across the board, is finding areas where there are widespread problems, where our current tools, case-by-case enforcement, don't really seem to be doing the job. And what can we do? Can we put together a rule that imposes no substantive obligations on market participants, but mitigates the 13B risk? And I'll just say quickly, we are, under this commission, undertaking a Mag-Moss rulemaking with negative option. We are also undertaking a Mag-Moss repeal with the care labeling rule, something no one asked us to do, but the commission has proposed to repeal the rule. So we have these tools. There's been an ideology at the commission for many decades that case-by-case enforcement under 13B is better, but that's not Congress, that's not out of the FTC yet. That's an ideology. So Commissioner Chopra does feel that we should be looking for areas with prevalent misconduct and evaluate whether case-by-case enforcement is doing the job, or whether we can impose rules that simply restate the law without imposing any new obligations on market participants, while dramatically stepping up deterrence and mitigating gamesmanship around 13B.
Let's go around the horn like ESPN. Austin.
So co-sign Sam's rulemaking speech. Commissioner Slaughter is keenly interested in using this tool that has seemed to gather some dust in the corner of the agency's garage. Magnuson-Moss rulemaking is feasible. It is more difficult than APA rulemaking, but also has really incredible breadth. Any unfair practice that is prevalent in interstate commerce can be regulated along with fencing in relief, like reporting requirements and other types of requirements to ensure that the law is being followed. And the agency ought to use that power to protect consumers, not just in the way that Sam suggested of codifying existing requirements on market participants, but also exploring new market requirements for market participants. Commissioner Slaughter has expressed an interest in a broad data privacy Magnuson-Moss rulemaking, which would be a huge undertaking for the agency, to be sure. But if Congress can't get its act together, someone needs to act. The Wild West of privacy in the United States needs to end. And if Congress can't do it, this agency has the power to do it and should. Commissioner Slaughter has also called for particular rulemakings in the auto space. She's keenly interested in this, and I think that there are a number of exciting opportunities for the agency to, really turn the car back on and take it out for a spin and become a 21st century rule writer with respect to these modern problems in our economy.
Let's give 45 seconds each, Eitan and Bobby, on rulemaking.
Sure. So I'll keep it at 45 seconds. One, I think Commissioner Phillips, I think you would find, I suspect Bobby will say something similar about Commissioner Wilson, is a go slow person on the front of rules, not necessarily opposed to all rules, but really need to think about the consequences, intended and unintended consequences of rulemaking, and when looking at rules and when making rules, to do so in an evidence-based way. I think, just as an example, earlier last year, when the NPR on the GLBA rule came out, Commissioner Wilson and Commissioner Phillips dissented. And one of the primary reasons for that dissent was that they did not feel that there had been sufficient evidence in the record to support the specific rules that were being suggested. The second point is, I think more broadly, especially when you get to real substantive rules, Commissioner Phillips does have a concern about 5 unelected bureaucrats making substantive rules that impact broad swaths of the American economy. Not only is it, in his view, undemocratic, but it is also provides little confidence to business that the rules will remain steady. Think about the FTC and the flip-flopping on net neutrality. So in many cases, I think that Commissioner Phillips would particularly on privacy, just to reflect on what Austin said, would strongly prefer that Congress reset the majority of the substance and not leave those types of democratic decisions to the bureaucrats at the FTC.
Yeah, I for one, have quoted Commissioner Wilson's statement. I think it was in the energy labeling rule. Overly prescriptive rules are not good for consumers. We don't need to prescribe the font size of labels and things like that. But I don't want to speak for her. So why don't you finish it off, Bobby?
Sure. Not right. Given that statement, not surprisingly, and Commissioner Wilson's, general free market views, she has stated that she shares this administration's goal of really taking a close look at the regulatory requirements and trying to, eliminate unduly burdensome and unnecessary requirements. And she very much appreciates the FTC's practice of reviewing its rules and guides on a 10-year cycle, sometimes even more frequently, and asking the questions to get the data that, Etan was talking about. What are the costs and benefits? What are the unintended consequences? Is this rule still necessary? And she is very open to looking at that data and looking at those comments. But the few times that she has written dissenting statements as a commissioner have been in rulemaking with the energy labeling rule and the safeguards rule. And more recently, she also she concurred, but she also shared concerns about the proposed Made in USA rule that, although she agrees that we have APA rulemaking authority to promulgate a labeling rule, she thought the proposal may have exceeded the authority granted to us by Congress on that rule. So careful, really looking at the market and the consequences and whether the rules are unduly burdensome or unnecessary would likely best represent her approach.
Thank you. And we're about 93 minutes into a 90-minute fireside chat. On behalf of our clients, friends, contacts, and everyone listening, this was just outstanding. And I learned something, and I think our audience did. Wonderful guidance from all of you. And we appreciate your time, and hope we get to do this with you in person one day at a real symposium in the future. But thank you, everyone.
And before we leave, the CLE code, again, is Fireside, all one word, FIRESIDE. And echoing what Eric said, thank you all for joining us, and everyone in the audience who we can't see, thank you for tuning in for the last hour and a half. I hope you've enjoyed it. Hope you've learned something. We certainly have. So again, thank you.
Thank you. Thank you for having us.
Thank you.